final case on the morning docket, 119536, in the matter of WL and GL, by and through their mother and its friend MS and EL versus EL Appley.
May I proceed?
Yes, you may.
Thank you. May it please the court, I am Valerie Moore and I represent the non-biological mother in this case. I would like to request 3 minutes for rebuttal.
3 minutes is granted.
Okay. This is a case where Melissa and Liz were in a long-term committed relationship. During their relationship, they purchased a home together, paid bills together, and lived as a family unit. 2 children were born during that relationship. At the time of birth, the children carried my client's last name. It was a hyphenated last name. So she had Liz and Melissa's hyphenated last name at birth. About a year after the children's birth, the parties separated. And for the next 18 to 24 months, Melissa saw the children every other weekend and one day during the week. At which point Liz
I have a quick fact question, counsel. The birth certificate, did it list both women's names as parents?
No, because that was not permitted. This was
It was still, gendered. Okay. I thought that was the case, but I wanted to make sure. And then what does the evidence tell us about what happened when the hyphenated name was removed?
The hyphenated name was removed unilaterally from the birth certificate without my client's knowledge or permission.
She didn't know of it at the time. When did she learn of it? Is there any evidence in the record on that?
I believe, I'm not sure 100% that's in the record. I believe when we filed this action, I actually filed it with the hyphenated name. Okay. And then we found out through the process that that was not the name anymore.
Thank you.
So these parties operated as a unit, and my client saw the children every other weekend and one day during a week for 18 months. She paid $18,000 in daycare expenses for the children, $9,000 in medical expenses for the children, as well as $3,000 in various other expenses for the children. She spent substantial time with the children and had a relationship with the children. She notoriously mentioned that she was the parent to these children. She held herself out as the parent to these children. In this case, is a little bit different because the district court level said if Melissa met her burden, then it was rebutted by Liz. One, I think that's error. I think the court has to either say she did meet her burden or she didn't. The Court of Appeals essentially said it's harmless because they went on to the next prong, so it didn't matter. But I think the very crux of this case is whether she notoriously recognized parentage of the children. Because if she did, the standard to rebut that is clear and convincing evidence, which is our second highest standard. And so when the Court of Appeals said she rebutted it, the Court of Appeals essentially said she rebutted it by showing there wasn't a writing, and that this court would have required a writing, that they failed to believe that Frazier would allow for parents to co-parent together without a writing when they are same-sex parents. And so that's what we're here for today, is essentially this fundamental question of whether notoriously requires a writing, if that is the requirement, and if you can rebut a prima facie case of parentage by saying there was not a writing. This case was heavily litigated, but the facts were not really in dispute. No one disputed that the kids shared my client's last name at birth. No one disputed that they resided together. No one disputed that these bills were paid for the kids. No one disputed that she had parenting time for the next 18 months after the parties separated. That was all undisputed. The only thing disputed was whether or not my client should be viewed by her actions as a parent. Liz focused an inordinate amount of time on the salacious details of the parties, that my client had an affair, that she behaved inappropriately, and because of that, she was not a parent. That is not the standard in any other action, and nor should it be the standard here today for the court. What type of parent my client is goes towards a parenting schedule, and the courts deal with that on a daily basis.
And what type of partner she is doesn't go to that.
Correct.
At all. It's just irrelevant.
And I had a standing objection. I objected to that from day one at the trial. Objected to that testimony getting in because I felt like it didn't go to the fundamental question as to whether or not my client was a parent. The district court allowed it in, saying that they will put up the wall and it won't sway him. I contend it obviously did sway him based on his statements in his decision, that he felt that my client was some kind of psychological or de facto, did not show that she was a psychological or de facto parent, and therefore was not a parent. Number one, that's not in the statute. That's trying a case and expecting me to try a case based on a standard I had no idea existed or I should be required to file a case under. My client, I contend she did show that she was a parent to these children. It was the perception of the other side, a self-serving perception, that she was not. My client had every other weekend and one day during the week. There are millions of decisions that a parent makes during that time period. What to feed the kids, what time to go to bed, bathing, if they scraped their knee, all of those little decisions that a parent made. But because she didn't pick out the pacifiers or know what formula the kids used, she was somehow less of a parent. The district court talked about how my client was not credible because she didn't know the donor number. There was a list of donors in the trial and she picked the wrong one to say what the child was. But she listed every single characteristic the same as Liz did when discussing why they picked that donor. And so the court just essentially ignored the mountains of evidence to say that my client was not a parent because there wasn't a writing and because she didn't meet the standard of a psychological or de facto parent, even though the court has essentially said that that's not the standard.
It was this case in which the court talked about a credibility contest, right?
Correct.
I'm sorry, I was confused about that earlier.
They are substantially similar, so it is easy to
There's
do that.
a beauty in putting them together, and there's a danger as well.
For me as well.
So it was in this case where Judge Smith talked about judging the credibility of your client more harshly, shall we say, than the credibility of the biological mother.
Correct.
But what you're asserting is that he, in essence, one thing that's a struggle here is whether his findings amount to negative findings, where the burden for you is tougher to get a reversal on appeal. And in the event we say that standard applies, you need to be able to demonstrate that there was an arbitrary disregard of undisputed evidence or a reliance on factors that were not appropriate in order to reach the judge's decision. How do you meet that burden if we say that's your burden here, rather than just substantial competent evidence competing?
I think two ways. One, in the district court's decision, he relies heavily on a case not out of Kansas.
Wisconsin case.
A Wisconsin case. And he relies heavily on this case.
And it's about how you show a de facto parenthood, right?
Correct. And
which is not what we're here for.
Not what we're here for. One, two, that's 20 years ago. That case was decided 20 years ago. It's not a Kansas case. It was 20 years ago, pre-same-sex marriage being legal in any state. And so that's a very specific case to that situation. And to use those factors and to use that standard when I had no idea that this was the standard the court was going to be using to determine if my client was a parent. I certainly would have presented a different case had I known that that was the standard the court was going to use. I was focusing on the notoriously or in writing, which frankly, the evidence was, I had a lot of evidence. There was birth announcements that list both the parents. There's, them announcing that the sex of the children, my client being present at the shower that was given to both of them. The fact that she had parenting time for the next 18 and 24 months after they separated. I don't know how much more I could have shown that she notoriously or in writing recognized parentage of these children. And so I think just a complete disregard of that was done by the district court. When they shifted the burden, I think they allowed the burden to be shifted based on the psychological parent. I would contend that if you're going to allow someone to rebut the presumption, the evidence presented needs to be extreme.
Was part of your case then that the baby showers were a written acknowledgement?
Yes.
So you were claiming both a written acknowledgement and in writing?
Yes.
I mean, yeah, right, both.
Yep. I was not claiming there was a contract. There wasn't one. I wasn't claiming that, but she certainly acknowledged parentage. There were statements of my children and Facebook posts talking about my boys. The evidence was voluminous regarding my client acknowledging that she was a parent to these children.
And I understand your position is that a similar type of acknowledgement from the biological mother was not necessary as a matter of law. I understand that's your position.
Yes, but I would also
But
say...
let's say that we're bothered by the tension with her 14th Amendment right. So would you say also there was evidence to support her acknowledgement of the parenthood of your client?
Oh, I think there was a lot. Liz said, "These beautiful boys are no more mine than yours. Together they are ours. There is no doubt they are yours. The boys deserve parents who can discuss their lives together."
Was that said in writing, or is that your client's testimony of oral statements?
These were in writing.
Okay.
These were text messages. They were Facebook posts. These were in writing for the world to see. There was emails from Liz to the daycare provider saying her mother and I alternate payments. So she is holding herself out as a co-parent with Melissa to daycare providers, as well as on social media. There was an acknowledgement by both parties that they were parents. There just wasn't a writing.
At some point, a guardian ad litem was appointed. When did that take place in this?
That took place at the very beginning.
At the very beginning, and so, as a consequence, I would assume best interests were kind of factored into this, or not?
I think that they were.
In reading Judge Smith's decision, he refers to the GAL briefly in his decision. How much did that factor in? And I assume your position is that it shouldn't, but.
Right. My position is best interest by statute only
Right,
comes
right,
into
I
play when there's
understand.
competing presumptions. I think where the disconnect comes, and I do think that this is probably a problem that district courts are struggling with, because we don't have a standard. It's not, Frazier said, yes, you can be a parent, but it didn't necessarily articulate a standard. Because in Frazier, I think at the very end of it, it was remanded and said for a guardian ad litem to investigate. And so because of that language, the district court felt that a guardian ad litem was mandated. Now, to be fair, I didn't disagree with that necessarily because, frankly, from my position, I had a presumption of parentage. So I could understand we would need a guardian ad litem to be able to weigh in once we got to the parenting plan portion of the case. But as to the legal question of whether this person is a parent, I don't think that that's a guardian ad litem's position to weigh in. It's a legal question. That's for the court.
Right. I see your point. So, in this context, I'm just trying to determine: is it appropriate to follow Frazier and appoint a guardian ad litem in these questions, or first establish whether there's a acknowledgement, whether it's parentage, and then do it? What's the procedure here?
I think that's correct. I think the proper procedure is, and in other cases that I have done, that's the procedure the court has used, is say we're going to make the fundamental determination as to whether or not you're a parent, and then we'll move on to appointing a guardian ad litem, unless there's competing presumptions. But when I've had a case where we've had competing presumptions of parentage, then yes, the court would appoint a guardian ad litem to kind of weigh in as to whether or not we needed genetic testing or whatever may be appropriate, or who the child maybe views as a parent, those kind of things. But that wasn't necessary in this case. And so the guardian ad litem, and I think she struggled with it. I think you can tell from, kind of from the record that she struggled a little bit because she was appointed to look at the best interest of the child in making a determination. So I think that was just an error kind of from the beginning.
But didn't, I'm sorry, maybe, I don't think I'm getting confused. Didn't you request appointment of a GAL?
I did. In my response to their motion to dismiss, I requested the appointment of a guardian ad litem or an independent custody evaluation, or an independent and I believe it was custody evaluation. So it was kind of an or. But again, if I remember correctly, the language discussing that was talking about my client's a presumed parent or a presumptive parent. So I was asking for it essentially from the standpoint of, once you declare my client a parent, let's move on to this next thing.
Okay.
But yes, I freely admit that the GAL, it was it was discussed and determined. But I don't think that that should come into play when making a determination with respect to whether or not my client is an actual parent. Any other questions I can answer?
Thank you, Kelly.
Okay.
Nicole?
May it please the court, Adam Hall for EL, who appears personally. This case comes to the court upon the findings of a district court. Those findings include that, well, first off, those findings were based on 2 days of evidence that was presented to the district court, and following a report by a guardian ad litem requested at the behest of MS regarding what would be in the children's best interest. Following a 2-day bench trial, and upon the recommendations of that guardian ad litem, the district court concluded that there was no agreement in this case for these parties to co-parent, whether that would be oral or written. There was no guardianship authority ever vested in MS. There was a power of attorney at one point given by EL to her own parents near the time of the children's birth, not given to MS, the putative parent for this case. The court found explicitly that MS did not meet the criteria of what it labeled, consistent with that Wisconsin case, a psychological, de facto, or functional parent. It made that finding to the standard of clear and convincing evidence. There was a finding that a person other than MS, the putative parent, was serving as a second parental figure for the children at the time of the hearing.
And how is that relevant to whether M was ever a parent?
So there was discussion, I think Judge Lieben at the time of the last argument posed a hypothetical. Well, let's say this mom has a series of 6 months relationships. We get to the hearing, there are competing presumptions. We have 2 individuals who are acting in a parental role or who have acknowledged their own parenthood of these children. How do we resolve that dilemma? Well, we resort to utilizing the best interest of the child and the weightier considerations of policy and logic. And I think that the district court didn't expressly do that.
No, I mean, there was no action pending to declare the parenthood of this individual to whom the biological mother is now married. I think they're married or linked. I'm not sure about that, but there's no action pending. There's no competing presumption for that person.
Well, there's no, that person wasn't a party in interest. I mean, that person wasn't represented by a lawyer and hadn't entered an appearance in the action, but it appeared, at least to the district court at the time that it's making these findings, that this individual is in the same role that the putative parent wants to then fill. And so the district court is weighing out, well, what would be in the child's better interest here? The decision on my part to make this person a parent and thereby displace this other person who is essentially fulfilling the same role.
Are the child's best interests a factor to be considered when determining parentage? Not parenting schedule, not who's more meritorious as a parent, just whether someone is a parent.
So the answer to that question is a little bit complicated. It's
That's
not.
okay.
It's
I'm
not.
listening.
It's not mentioned in the statutes except under the competing presumptions
Right.
of parentage. It is mentioned in the Marriage of Ross case, where the court, I think it's in syllabus 2, says we consider the best interest of child in deciding
That's
whether or
about
not.
disrupting a kind of what's sort of like a de facto parent, maybe.
And here
Well,
there
this
was.
isn't Ross. We're not in Ross
Sure.
land here, so.
But similarly here, I mean, the facts are that the district court has to make a decision as to whether or not to disrupt the child's now existing family unit that is now existing at the time of the hearing. It sees, here's evidence that there's another person fulfilling a parental role, and it has a putative parent who's trying to come in, and our argument is usurp the role of that other person fulfilling that existing role.
How does it get to that question if the action is an action under the Kansas Parentage Act? as you've already said, this other person is not an interested party. They haven't filed to intervene. So there's only an action between one person who is claiming under the notorious or in writing presumption and the biological parent. So how do any of the issues you're just describing worm their way into the action?
I mean, I think it is how the district court analyzed the case.
I understand that. I'm asking legally. The action was filed under the Kansas Parentage Act. So how does what you're now describing become the legal issue properly before the court?
Because to my mind, the district court was weighing what it perceived to be competing considerations with respect to weightier considerations of policy and logic, with respect to the best interest of the child about whom it was making a decision about what that child's family is going to look like and who that child's
I think
parents
what
were
we're
going to
asking is that legally appropriate
be. Was it legally appropriate?
for the district court to do that? Was it correct as a matter of law? And if it wasn't, we have a problem, right?
Yeah, sure.
Can you answer that question?
Sort of. So I can answer it by saying if the court finds that it was improper for the district court to have considered evidence of the existence of another parent-like role between the child and another individual, it very much appears that that's what the district court did. But the district court engaged in an extensive and child-centered analysis, and that would not be the only basis upon which its decision ultimately lay. The court also found that the children would be subject to emotional injury if, well, I'm going to skip that because it relates to the same thing, that it would be more detrimental for the children to visit with MS than to not visit with MS, and ultimately that it was not in the children's best interest to establish a parent-child relationship with MS.
Are any of those relevant to a determination of parentage? Any of those facts?
Other than, as I stated from that quotation from Syllabus 2 of Marriage of Ross, then I think the answer to that question is no.
I have another question, counsel.
Yes.
Talking about the district judge's reasoning, at one point in his decision, he recites some credible evidence potentially establishing the parentage presumption in favor of the non-biological party, talking about the birth certificate name. And then he said, that action had since been undone, and I'm going to quote here, the testimony of the respondent, your client, is that this act, along with several other acts which might be construed as a mutual intent to parent, were all done in a futile attempt to hold out until the petitioner made a sincere commitment toward both the then existing family unit and parentage. That sounds to me that, like he said, the evidence before me demonstrates that both parties were attempting to co-parent for a period of time. Is there something else that that's supposed to be saying?
So, as I recall the words of the district court,
Those were the words. I just read you that passage.
he said that the effort was futile. He had hoped that
But
MS.
the effort was made. And that goes to the idea of whether there was an agreement. There certainly wasn't a written agreement. This isn't Frazier. This is a situation where things were left uncontracted, unwritten.
So, two thoughts on that question. One is he made an explicit finding that there was no agreement. I mean, so he even considered those facts, but also considered the other facts that he heard during that 2-day trial and ultimately concluded there was no agreement to co-parent here.
There was no written agreement. There
Wait.
was not even a formal oral agreement. But doesn't that necessarily imply at least consent on the part of the biological mother that this other person would be a parent? And then later there's the decision that she hasn't stepped up enough?
I think that his conclusion was that it was an intention on her part initially that bore no fruit, and his ultimate conclusion
And
was
who
that
got
there.
to decide whether it bore fruit? Because really she decided unilaterally, didn't she, after about a year? And I'm not saying there wasn't reason, because remember the 3 buckets I tried to address with previous counsel? Parentage, bad versus good parenting, and then finally bad versus good partnering. There may have been valid reasons, but does that empower the biological parent to essentially withdraw any consent that was either verbalized or implied by action?
So he, again, his ultimate conclusion, I recall the words, there was no meeting of the minds, which to me is an essential requisite of an agreement that would be enforceable by this court. So he acknowledges that there was evidence of these actions on the part of the biological mom, but he concludes that those actions were not sufficient in his mind as the finder of fact to amount to an agreement or a contract between the parties.
Do you agree that the biological mother sent out joint birth announcements?
Yes, that was evidence.
And the other quotations that Ms. Moore gave of written things from text and otherwise were said by your client?
Yeah, I believe that evidence was at trial. I think the judge, to some degree, credited that evidence. Now, he talked...
But it seems like what the judge is doing is saying there wasn't a meeting of the minds as to how this parenting deal was really going to work, that it would be equal parents and you'd really do your role and you'd step up to the plate, as opposed to, under the statute, notoriously recognizing this is the other parent of the child. And so I'm wondering, isn't the evidence undisputed that your client openly recognized the other party as a parent of this child?
She, I think there were the references made by Ms. Moore. The evidence was that she called her mom or mother on one or more occasions. But to my mind, it's up to the district court to determine, well, at what point do those efforts become?
If the standard is just notoriously recognizing a person is the parent of the child, if that were the standard, and going back to Justice Byers' question about the negative finding standard, isn't there undisputed evidence in this case that your client did recognize the other woman as the mother of the child?
Yeah, I mean, I have to concede that that's the case, because I think that's what the evidence was.
So what more is required?
So looking at the framework for the statute, it's Kansas Parentage Act. The object was to determine, was there a parent-child relationship between MS as a putative parent and the children. That relationship is defined. MS then comes forward with evidence that she says is sufficient to meet her initial burden, which is, look, I notoriously acknowledge that I am the parent of these children. Well, this court has to first determine, well, what is that? When she says acknowledge that she is the parent of these children, what does that mean? And an argument, or our argument, is that that means that she's saying that I am the biological or adoptive parent of these children. That's the object of the presumption. So then EL goes forward to try and rebut that presumption. And the district court, in its analysis, said, look, MS says that she was a parent to these children. I'm going to look at the efforts that she made to, by function and by the children's psychology, from the children's perspective, determine whether or not she functioned as a parent.
Why would any of that evidence be needed if the presumption if the object of the presumption, as you put it, which I think is a helpful way to phrase it, is biology or adoptive relationship? That's easy to rebut in this case, is it not?
No, and I think it was undisputed that there was no biological...
But that's certainly not what
The district
Frazier
court.
indicates. That's not the status of the law in Kansas, is it?
Well, so Frazier, on that topic, talked about the presumption from that subsection A, subsection 4. And it didn't go so far to say that it is not probative of a biological relationship. As I recall the language in Frazier, it was that a putative parent can make a colorable claim of parentage utilizing this presumption without a biological connection. Because the presumption is probative of another fact. They don't have to plead the underlying fact. They can plead the presumption to get themselves to the court believing that the underlying fact exists. Then the question is going to be, well, how can that presumption be rebutted?
How could Frazier have come out the way it came out, if your description's accurate?
Because there was a waiver. I mean, to my mind, Frazier came out the way that it came out because the argument that there was a fundamental interest on the part of the parent to parent that child was defeated by the fact that that parent in writing said, this is exactly what I want to happen. I want this other person to parent with me and have the same parental rights.
But Frazier's conclusion was not, okay, we believe that the, as you call it, putative parent is biologically related. That wasn't the conclusion.
No, I agree. I agree with that.
It had to be something other than biology. I think it's that something other that we're trying to figure out what that is.
In terms of how Frazier came out the way that it did.
Your argument is that that something other is an agreement.
Yes. So going back to the reason we're here. So the court takes review on the issue of is a written agreement required, and the thing that we've not talked about is the fundamental right of parents to direct the upbringing of their kids on their own and to the exclusion of others. And we cited the court to the Troxel v. Granville case. And our concern is that if the court construes the parentage statute in a way that is requested by MS, the court will create a violation of parental fundamental rights, unless it puts in place a method by which you ensure that a waiver of those rights takes place. And
It's not really a waiver, it's a sharing.
well, we just like a person consenting to a search of their car can say, you can search my trunk, but you can't search the back seat. Well, to my mind, that's still a waiver of your right against an unreasonable search or seizure. In the same way that the waiver exists here. I, as a parent,
So what is it about the statute that tells us that we should say that it must be in writing, or at a minimum, a formal oral agreement, as opposed to a lot of behavior that indicates that's exactly the intent of the biological parent?
so I think you have to look at a number of statutes to get to that conclusion as to why that's the appropriate thing to do. First off, I don't think the Kansas Parentage Act was not designed for this purpose. I think the Parentage Act was designed to find biological dads that were not supporting their children. So when there was an acknowledgement of parentage on dad's part, that was a party admission that could be used against him. That subsection, I don't think, was designed to be used sort of offensively.
In other words, that's why it's a presumption, right?
Right.
It's a way to establish something that already exists,
Right, which would be,
as opposed to a way to create a relationship.
I think that would be my position, yes. So, but looking at the way that the law has developed in Frazier, I still think you can square Frazier and the written agreement requirement with the Kansas Parentage Act. But you still have to be mindful of other things, like the potential for a violation of a natural parent's fundamental right to parent. And we look at the other statutes that govern non-biological parentage. We have the Assisted Reproduction Acts. That talks about a writing consent by a husband and wife to the procedure. We have adoptions that requires a written consent of the natural parent. Those are the sort of two principal ways that the statutes contemplate that non-biologically related individuals can come to have the parental rights that natural parents enjoy by virtue of having conceived of the children naturally. So I think that if this court requires that there be a writing, it will, including a waiver, it will ensure that any problems that might arise by virtue of an invasion of the natural parents' rights would be staved away, because there would be evidence of the
So if the parties
waiver.
have not had the foresight to put it in writing, then the biological parent will always have the ability to unilaterally dissolve whatever relationship has existed between the child and the non-biological partner.
It seems like a harsh result in
It
the
does
way
seem
that
like
you
a harsh result, that's
in
why
the
I'm
way-
asking the question.
that you stated. And there have been cases historically, as I recall the Troxel case, there was a strong relationship between the children and this other individual, and the U.S. Supreme Court held that the parents still had the right to direct the child's upbringing as against that strong relationship. The court analyzed the statute that authorized non-parental visitation and said, this is too broad. We're not going to permit others to come in and have visitation with children over the objections of their natural guardians, absent evidence of unfitness or that sort of a thing. And my concern, and I think I stated this explicitly in my response to the amicus brief, but my concern would be that this court would sort of run afoul of that precedent if it construed the Parentage Act or Frazier so broadly as to say, look, you don't need a written agreement, you may not even need an oral agreement, and there's just going to be a certain amount of action that can take part on the part of a putative parent, and that will be sufficient under the KPA. Because to me, that would
No,
open...
I'm not even suggesting that. I'm suggesting a further step, that the biological parent has also engaged in a great deal of conduct or written things, etc., that demonstrate that it was that parent's desire to co-parent.
Yeah, so...
Which is equivalent to an agreement to co-parent. It's not detailed the way that the Frazier documents were, but it's a consent. Can that not be the waiver that you're saying is necessary to avoid the 14th Amendment issue?
So first off, in other contexts, I agree that constitutional rights, even fundamental ones, can be waived without something in writing. So, again, in the Fourth Amendment context, you can authorize an officer to search your car.
It happens all the time when
Yes.
people waive jury trials.
But I think in this context, when you're talking about family planning, and with the context of the other statutes prescribed by the legislature, the lawmaking body of the state, as to how we establish parenthood in people who are not biologically related individuals, I think this court should follow the lead of the legislature and act in a way that is protective of the rights of biological parents by making there be a requirement of a writing. I think that provides families in Kansas with certainty and predictability in their arrangements, and it's consistent with those statutes. I think it provides protection for the constitutional rights of the natural parents, and it ensures that there is a knowing and voluntary waiver of a constitutional right. I think it also, if you went the other direction and didn't require that writing, I think that you're going to see an increase in family law litigation related to a question that is very fundamental, which is, well, who is a parent? And again, in my response to the amicus brief, I pointed out, and I have this is my concern, is that, kids are placed in the charge of people who are not their parents all the time. They call people mom and dad who are not their moms and dads. They develop important and lasting bonds with people who are not their natural parents. So, and that includes grandparents, who the legislature has given grandparent visitation rights under statute, and step-parents, who the legislature has given step-parent visitation rights under this statute. And my concern would be that those people would then come in and claim parentage of these children, given their substantial bond with them. And I think that there's also a considerable danger that there will be a lot of litigation related to those relationships and avoidance of what the legislature prescribed for the regulation of those relationships within the statute of the state. I think you'll see a decrease in adoptions if you have the option of just entering into a written co-parenting agreement. And of course, adoptions have a lot of judicial oversight, where judges are concerned about people paying for children, so they look at the amount of money that is associated with that. There's home studies, and those protective efforts are going to be not required if you just have a writing requirement, or no writing requirement, I guess.
Are there other questions? Thank you, counsel.
Liz's argument seems to rest on the idea that Melissa was some kind of weekend babysitter, that she just watched the kids on occasion. This was somebody who she gave the children her last name at their birth, somebody that she allowed and fostered a relationship with, allowed the children to go every other weekend and one day during the week. She's a parent. That is a parent. That is not something you do with a babysitter. The other side talked a little bit about adoption. That wasn't a possibility. Statute said no, and the case law said no. You couldn't do it absent a marriage, and they were not legally married because it was not recognized in Kansas. So that was not an option that was afforded to them. Could they have entered into a written contract? Yes. Would that have been preferred? Yes, but they didn't. And that doesn't mean that they didn't act in accordance with that.
Counsel, let me ask you to respond to one of the arguments your opposing counsel made when he said that the other statutes that allow non-biological parents to gain parentage, either for adoption or with the artificial insemination, do require writings.
Yes.
Should we look at that requirement of a writing established by the legislature there and graft that onto this statute, which everyone would concede was developed at a time when none of what we're talking about today could have even been envisioned?
Well, when we talk about the artificial insemination statutes, there's like 3 of them. It is not a voluminous area of the law. And generally the only purpose on those statutes was to make sure that a wife didn't go get inseminated and the husband had no idea, that he had to concur with that. That was the point of it, because they were legally married and he's going to have a presumption of parentage. And likewise, when we talk about the adoption statutes, you're terminating usually someone's rights. So that's different. We're not terminating anybody's rights. We are confirming what they have already done. These children entered the world with 2 parents. We're just asking that continue, and that the court codify essentially what they were doing in practice. I will stipulate, as the court mentioned, my client was maybe not the best partner, but that doesn't mean she wasn't a parent to these children. And to allow one parent to unilaterally destroy a relationship that she fostered and made sure continued even after the parties separated is unfair. The testimony at trial went into that specifically. She never told Melissa that she no longer viewed her as a parent. She testified that when she stopped being a parent when she had the affair, but she didn't tell Melissa that, and still let Melissa see the children every other weekend and one day during the week. Still referred to Melissa as mother when talking to the daycare providers and to others. It wasn't until right before we filed this action is when she notified her that, oh wait, you're not a parent. We are allowing her the ability to create and break relationships based on her relationships with someone else. I think it was completely inappropriate for the court to even remotely discuss Liz's current spouse in the paperwork. She was not married to her at the time the action was filed. They got married during the action, and she was not an interested party. So if that's our standard, then a step-parent's always going to be preferred because they're in the home. And that's not what we've allowed in other situations and should not be what we allow in this situation. I'm not asking you to go out on a limb. I'm asking you just to do what you've already done and just say that the Kansas Parentage Act applies, regardless of gender. That if you show that you notoriously or in writing recognize parentage of the children, and that goes both ways. Liz notoriously recognized that Melissa was parent of these children. That if you do that, if you're in for a penny, you're in for a pound. That if you are going to say that this is a parent and your actions include saying that this person is a parent, they're a parent. You don't get to decide that they're no longer a parent because it doesn't fit with your lifestyle or your narrative now. So we're just asking that you remand it with the finding that Melissa is a parent and that they move on to the discussion regarding a parenting plan. Are there any other questions?
Thank you, counsel. The court will take this matter under advisement